Hello, everyone. Welcome back. This is James Anderson Law Firm here in beautiful downtown Fountain Inn. I hope everyone's doing okay today. I'm real excited to have a presentation prepared for you, which I've wanted to put on for quite some time now. A little thing I call Dave Ramsey's Curious Estate Planning Advice, Estate Planning Fundamentals. This is part one, dealing with probate, wills, and powers of attorney. I'll preface this with a disclaimer. Nothing we're doing here is legal advice. Okay, any information relayed over the course of this program is educational in nature. In order to give proper legal advice, there would have to be an opportunity to address a particular set of circumstances. Okay, so do not assume that anything that I mention here applies to you or is direct legal advice that I'm giving to you. My intent here is that we give you some food for thought, some things to think about, educate you more on the finer points of estate planning, so that you can deal with your attorney if you have one, and look at your own estate planning with a fresh set of eyes. Or if you don't have any estate planning in place, maybe as an inspiration to you to move forward with that. Okay. So all that having been said, the genesis of this presentation was a conversation I had with a prospective client back in 2013 or 2014. Long story short, we were going through this person's options and recommending some things, and this prospective client came back and said, well, I'm a big Dave Ramsey fan, and he says I really don't need anything that you're talking about, and I just don't know. And that was the end of that. So that inspired me to do a little bit of research to try to get a feel for Dave Ramsey's brand of estate planning. And frankly, I was appalled at what I saw and read and heard. And I want to kind of unpack these things for you and help you. Well, this creates a great forum for us to be able to really take a nuanced a look at estate planning and shoot down some common fallacies that are out there. So without any further ado, I'll share with you some specimens here. These are things that we've taken off of Mr. Ramsey's website. So a question is posed to him. It says, Mark asked Dave to explain the difference between a will and a trust. And Dave Ramsey says, everyone needs a will but not a trust. You leave money in a trust by virtue of your will. The will tells everyone what you want to do with your stuff and your kids when you die. The will can say leave the money in the trust for your kids. You need a will, but not necessarily a trust. All right? It says the living trust costs up to $4,000 and is highly pitched, but is overdone in the estate planning world. It's not needed nearly as often as people say. It's more of a gimmick. You can save on probate taxes, but you operate your life in a trust, which is a pain in the butt. Okay, I've got the URL for that, so I'm not making that up. And then furthermore, he says the easiest and most cost-effective way to go about making a will nowadays is to use an online legal service. Dave recommends uslegalforms.com. Go figure. Another specimen here. A listener asked, Anna Washington wants to know when to create a revocable trust, especially if you own real estate, and believes it would be easy to have everything in one place and beneficiaries to leave assets to. I agree with Ann. Dave doesn't believe Ann needs one, even though it does provide some liability protection. Spoiler alert, it does not. Answer, you can form a revocable trust if you've got estate tax problems. There are some things you can do there. If your estate isn't over $5 million, you probably don't need to have any. You probably don't have any situation that the revocable trust is going to be needed for, with the exception of sometimes we're dealing with folks who are famous and in the limelight, and they often will put their homes into a trust, a little more for a privacy thing. But there's not any real huge tax advantage for being in a trust. It's just a pain in the butt. I think we can detect a theme here. He goes on, it does give you a little bit of liability protection in those situations. It doesn't. If you have a large number of assets to where you're a target, a trust on your home makes sense. But if you're a rock star of some kind, it makes sense from a privacy standpoint. If you're using it for some kind of estate planning tool, it might be there. But But just for convenience, it's not convenient. It's inconvenient. Just for the purposes of estate planning, you can just name that in a will, and it's fine. It does avoid probate. If you're in an area where probate's really, really expensive, all right, maybe you can do it. I wouldn't move your home into a trust unless you know that you're going to be there a long time. You've got to file tax returns on it every year. Not true. Anytime you get ready to do something, the trustee has to be involved because you no longer own the property. Again, not true. The trust owns the property. It sounds like it's some kind of sexy estate planning tool, but honestly, I don't recommend them. I don't use them. I've got some revocable trusts and things of different types in our estate plan, but that's because of the size of it and the complication of it, not because just the convenience of it. There's definitely nothing convenient about it. All right, so as I say here, there's so much to unpack. There's so much misinformation contained in those pearls of wisdom there. So let's just start working our way through this. So I want to kind of attack kind of the threshold presumption in that anthology of statements that we have there, which is he leaves us with the impression that everyone needs a will. And so you might say, well, James, do you think that everyone needs a will? No, I don't. And you say, why? Well, I'm glad you asked. But really to properly answer that question, we need to take a step back, and we need to think about the different ways that mechanically assets will go from point A to point B at someone's death, how that ownership changes. And it's real important that you and anybody else roaming around out there understand that assets can and will pass by way of probate or something that we call operation of law. Examples of that would be maybe a husband and wife owning their house as joint tenants with rights of survivorship, where one spouse dies. It could be life estates for real estate. It could be the difference between having the word or and on your car title. Okay. It could be what we call operation of contract. Ready examples of that are beneficiary designations on life insurance policies and annuities and IRAs and 401ks. It could be transfer on death directives for stock accounts. It could be pay on death directives for bank accounts and checking accounts, savings accounts, CDs, whatnot. All right, but it's important that you understand that wills only control what happens to those assets that pass through probate upon our death. Okay? Wills only control what happens to those things that go into probate when we die. And you say, well, what goes into probate when we die? Generally speaking, if we die and something is just in our name and we have made no other provision for it, for instance, if it's not going to pass by operation of law or contract or some other way, we would expect that those assets are going to have to go through probate. Now, in the state of South Carolina, at this point, if those things going through probate consist of any interest in real estate, no matter what it's worth, or cash or personal effects, business interests, stocks, whatever, worth more than $25,000 in the aggregate, long story short, we're looking at a fairly lengthy process, which I'm going to describe momentarily. Okay, but for now, I want to make sure that you understand that our wills not only do they not avoid probate, they just operate within the parameters of the probate court system itself. Okay? Again, I cannot overemphasize this. We tend to borrow from what we see in television and the movies. We tend to have this idea that if somebody dies and they had a will, everybody goes to the lawyer's office and there's a reading of the will, and magically property gets transferred and checks are written and everybody rides off into the sunset. And if that's the way you think that it works, you're in good company. That's what most of us think at some point or another, but it's just simply not the way it works. Okay, so our wills don't avoid probate. Our wills really don't expedite probate. Wills only work to give us a voice from the grave in the probate court to direct how we want those assets going through probate to pass. Okay, so you say, what is probate? Well, I define that here. This is my own definition. I say it's the default county level governmental mechanism by which control and ownership of a deceased or incapacitated person's assets or transferred. All right, and basically probate comes in two flavors: what I call dead person's probate and living person's probate. Okay, and we'll discuss what that is. So let's talk about dead person's probate. So I always pick on myself. So if I were to perish on my puddle jump of a commute home this evening, and if I died with, say, any interest in real estate just in my name, or any other assets just in my name that I've made no other provision for, then my wife, Kate, she's got her work cut out for her. First things first, she's going to have to dispose of me, deal with the undertaker, make those arrangements. The undertaker's going to do her a favor and help her obtain multiple, 10, 15 copies of my death certificate as proof that I've died. She's going to have to prove to people that I've died, and they won't just take her word for it. So those death certificates really are the keys to the castle. Administratively, she can't do anything on my behalf until she has proof that I've died. All right? So once that stack of death certificates come in, Kate's going to have to hop in the car and make an arduous trek up 385 North to the county square to the probate court, and she's going to file one of those death certificates as proof that I've died. That's going to, kick off that probate process. All right. Kate's going to have to petition the court to be named my personal representative, my executrix, if you will. Get plugged in as the quarterback of my estate to be able to deal with the probate court itself, to deal with my property that's going through probate, to deal with my creditors and my heirs. She's going to have to inventory and appraise what's going through probate. She's going to have to run advertisements in the newspaper for the benefit of my creditors, saying, "Hey, if James owed you money, well, get in line. You got 8 months to file a claim." And so she has to hold that out for that 8 month period, and then when that closes, then she has to deal with whatever claims came in, and then whatever is left goes to my heirs. All right. Now, in my case, it's pretty straightforward, because if this happened, I would be survived by my spouse, and I don't have any children, at least not of the two-legged variety at this point. And so what would happen by default is, in the absence of a will, the state of South Carolina is going to define who my heirs are. All right. And in this case, my sole heir would be my wife. And that's good, because I don't want everything to go to her, of course. I am well trained. All right. But let's mix it up a little bit, and let's assume that I wound up being survived by my wife and children of mine, who may or may not be children of ours. All right. They might be legitimate. They might not. They're all the same under the law. Okay. And so if I wind up being survived by my wife and children, then something maybe a little bit counterintuitive is going to happen at that point. At that point, whatever I have that's going through probate is going to be cut in two. Half goes to Kate, and then half goes to my children, who may or may not be our children. Okay, so therein lies the rub. Okay, so there's been many a surviving spouse caught off guard, caught by surprise in that scenario. And I suppose that the moral of the story is that it's not a good idea to die without a will, particularly if you stand to be survived by a spouse and minor children. Okay, because if we rewound the tape, and if we assumed that I did have a will prior to meeting my premature demise on my way home tonight, a lot of the same things are still going to happen. Kate is still going to have to prove to folks that I've died. She's still going to need to get that death certificate for me. She's still going to need to go up the road to the probate court and file that death certificate as proof that I've died. But this time she's going to have another document with her. This time she's going to file my original will. Okay, and just like before, this will kick off a roughly year-long, maybe longer process. But at least the difference here is that through that will, I have a voice from the grave to kind of direct traffic in probate, and with some limitations, but generally speaking, I can override a lot of those default rules as to who my heirs would be. So if I was survived by my wife and children, I could say, "All right, Kate, if you survive me, everything goes to you. But if we're both gone, then it goes to the children, or wherever I want it to go." Okay, and I can have a simple will that's just a few pages long, maybe doesn't do a whole lot, or I can have a beautiful, 20, 30, 40-page sophisticated will that covers all kinds of contingencies and may create trusts for people at that point. But from an administrative standpoint, it's all the same. If me or you or anybody else out there in this state, if we pass away with assets of any substance just in our name, someone close to us is going to be spending a year, give or take, sometimes a year and a half, maybe longer, going back and forth in government level bureaucracy. And the people in the probate court are nice and they're helpful, and they understand they're dealing with grieving people, and they're frankly very accommodating. But there's probate nonetheless. That is an administrative burden. Most people would say, but yeah, that's in a nutshell. That's what I call dead person's probate. Now there's also probate for the living, and that's worse. Now let's say I don't die on my way home, but let's say that I sustained some kind of injury that rendered me unconscious. I'm incapacitated, whatever it is. I'm not out there in a position to continue to transact business on my own. Now, just because I'm married does not mean that my wife can step into my shoes and sell my property, even if she owns half of it. She's not going to automatically be able to transact business on my behalf. All right, and sooner or later she's going to need to, and she's not going to be able to. What then? Well, maybe you see where I'm going with this. It's going to be back up 385, back up to the probate court. But this time she's going to be suing me in the probate court. And say, probate court judge, please, I beseech you. My husband James here, he's incapacitated. Here are all his doctor's notes and medical records supporting my contention that he's incapacitated. And probate court judge, I need you to give me a magic piece of paper naming me the guardian of James's person and the conservator of his financial affairs. All right. And, maybe some of you know Kate, probably most of you don't. But if you knew her, you'd probably like her. I like her, of course. And the probate court judge would probably say, well, Kate, we reckon you seem trustworthy enough, and, James is clearly incapacitated. So we're going to grant your wish. We're going to give you a piece of paper naming you the guardian of James's person and the conservator of his financial affairs. And so now she has a piece of paper that she can take around town to transact business on my behalf. Okay? And at this point you say, well, that was, kind of a bit of an ordeal. She had to spend money on attorneys and, maybe a guardian ad litem, so on and so forth, court costs, but at least all's well that ends well. Well, okay, yeah, but what the probate court is doing, they're saying, well, Kate, we reckon we like you, okay, but we don't trust you entirely. And they don't trust her entirely because they can't trust anybody. The court has to appeal to the lowest common denominator, and the fact of the matter is that incapacitated people are routinely preyed upon, sometimes even by spouses or by adult children. And so what they're going to have her do is have her come back periodically and open up her books and deliver an accounting, and she's going to have to demonstrate that she's using, whatever my estate is considered to be at that point, using that for me and nobody else. Okay, so as you might imagine, that has the potential to create some pretty serious economic disruptions within that marital estate. So I always tell people, the negative consequences that tend to flow from not having planned for incapacity from a practical standpoint, from an administrative standpoint, those negative consequences tend to be a whole lot worse than the negative consequences that tend to flow from not having adequately planned for what happens to my stuff when I die side of the coin. So, reasonable minds, I suppose, can and do differ on that. But that's my take based on, experiences we've had with clients. So all that having been said, when would a will be appropriate? Well, for starters, if you know that everything that you have is going to wind up going through probate at your death, and you're okay with that, and you want that, then then yes, you need a will. That's going to allow you to plan for contingencies and have a voice from the grave that's actually going to control the ultimate disposition of all of your assets. Okay. Another instance would be if there are minor children, because there's a real useful function of a will. You can designate guardians for minor children. Okay. But other than that, we are, as estate planners, we are best served by getting educated to the point where we can analyze the different moving parts that comprise our estate and know how they're going to pass. What's going through probate. Or if I don't want it to go through probate, what can I do to allow things to pass outside of probate? All right, but we're going to talk more about that later on. But for the purposes of our conversation today, if we're to say, James, what in your mind, what's the most important estate planning document? Easy. I tell people if you only have the budget or inclination to have one document prepared and to have that document prepared correctly, really, the foundation of a decent estate plan is a durable power of attorney and healthcare directives, because that durable power of attorney is our first line of defense against living persons probate, against that guardianship and conservatorship. The durable power of attorney is going to allow you to say, I'm going to let my spouse, or I'm going to let my adult child, or whoever, step into my shoes and transact business on my behalf. Okay, so that's something that in the event of your incapacity can be given to third parties, and if those third parties do rely on that document, that really lessens the administrative burden for those that would be in a position to handle your affairs on your behalf. By extension, having a set of state-specific healthcare directives is vitally important, because that, for a number of reasons. But the main one is that gives you a platform to let your people know what your thoughts are about organ donation, about the pull the plug question, about feeding tubes, those things. And depending on how you fill that out, that really can also take a big emotional burden off of those closest to you. Okay, so there was so much wrong with, in my mind as a practitioner, so much wrong with Mr. Ramsey's estate plan advice, and we're just beginning to peel back the layers here. But I'm about to shut this presentation down at this point. The moral of the story up to this point is this is bad advice fundamentally, because the advice given, first of all, assumes that anything somebody has is going to be automatically controlled by a will. Okay, it doesn't take into account the fact that things might pass by operation of law or contract. But over and above that, it's absolutely silent as to the issue of incapacity planning and what happens when someone does not adequately plan for incapacity. Okay, so for our purposes up to this point, I'm going to say, today I'm bickering with Mr. Ramsey on the point that if someone's going to do one thing, it really doesn't need to be a will. It needs to be a power of attorney and healthcare directives. And everything else over and above that, in most circumstances, in my mind, is you're just building on a foundation. And so you say, well, what about trusts? There was a lot of talk in those excerpts that you shared with us, James. What about trusts? Well, trust me, we're gonna stay tuned. Stay tuned. Next week or the week after, we'll have part 2, and we're going to talk about traditional will and probate-based estate plans versus trust-based estate plans. And spoiler alert, I think everybody ought to have a trust, but that's me. So thank you for bearing with us up to this point. I hope that was educational, or at least got you thinking about some things. But I'm going to we wanted to play around with something here in the office, and as a way to try to help you folks get to know us and get a feel for our personalities. And I want to introduce you to our dear friend Mahlon Cameron. She is our producer / marketing coordinator, and she's been dutifully switching all the scenes and audio sources and our chroma key background and all that kind of stuff. But if you know to know Mahlon is to know that Mahlon loves her mutts, particularly pit bulls. And I thought it'd be fun to talk about Mahlon and her dogs today. So, Mahlon, are you there? Technically, is everything working okay on the other side of this
I'm here.
the screen?
Can you hear me?
Yeah, I can hear you.
Well, hi, I'm Mahlon. I'm the marketing director here at Anderson Law Firm, and like James said, I do love my dogs. In particular, I have all pit bulls, 3 of them. And I guess I'll tell you a little bit of background on why I fell in love with pit bulls. I had my first pit bull in college, and like most people, before I had a pit bull, I gave into the stereotype that pit bulls were scary and mean and they would turn on you, but once you get one, you'll quickly realize that is not true. Like I said, I have 3 of them now, so I guess 4 pit bulls later, I'm sold on them for life.
And you got your third one within the past year.
I did, yes. We rescued Soup, our newest one, from Greenville County Animal Care. Actually, he was pulled by a local rescue, and we fostered him, and foster failed.
But by then, he tugged on your heartstrings, and
he just fit right in to where we couldn't remember what life was like before him.
So all's well that ends well there. But speaking of fostering and all that, you do a lot of volunteer work or you have in the past anyway, at the Greenville County, what do they call it, Greenville County Animal Care?
Greenville County Animal Care, yes.
Which is considered to be a kill facility?
It is, yes. They are county funded, and they take in all animals from Greenville and Spartanburg County. So, unfortunately, sometimes they don't have an option.
And if we're talking, if we're sending this out there to somebody who's considering adding a 4-legged friend in their family, where would you recommend that they go? The Greenville County Animal Care, the Humane Society, the pet store? What?
Well, obviously, adopt, don't shop.
I have to agree with that.
Adopting from anywhere is better than paying for an animal. But I always tell people to go to Greenville County Animal Care because they are a kill shelter, and you are saving 2 lives by rescuing a dog from animal care, the one that you're actually adopting, and then you're making space for another animal.
That's a good point. That's a good way of looking at it. And actually, we have some clients who have who've set up some ongoing legacy gifts for the benefit of the of Greenville County Animal Care to more or less to continue to sponsor a certain number of animals, get them off of doggy death row, if you will, for close to perpetuity. I mean, the way this is set up, it can continue on for quite some time, and that's something that, as an office, we're all animal lovers here. That's something that we're all proud to be a part of. But anyhow, well, I guess we're kind of out of things to talk about for now. But thank you for sharing this time with us. And again, we'll be back in a week or two with part 2 of this. Betsy Tanner from the office will be, God willing, technical challenges notwithstanding, she'll be talking to you next week. Anyhow, hope you all have a great evening and a good rest of your week. Hello, everyone. Welcome back. This is James Anderson, Anderson Law Firm here in beautiful downtown